enigma signifies much more than not being able to see. The irony of enigma is precisely that through enigma, you see much, much more. Enigma is the sign of forgotten references. In Quintilian and elsewhere, and in Perez, enigma is the sign of a didact, a pedant, a pedagogue. Enigma is the sign of histories, literatures, Sibylline leaves that have been forgotten and need to be recuperated through slowing down. Nietzsche's slow reading, Nietzsche's attention to the time necessary to acquire an understanding of the symbolic, which is a necessity for an understanding of the ancients. And so, enigma is blindfold, but the blindfold is simply a way of saying that you need to be led. And Iglesias's image of faith, the faith that subtends all learning and all law, is simple enough. Carrying her baby, Faith is transported into the clouds, into the other world, while she is blindfolded. So, we arrive then at the most remarkable image. I'm afraid I hadn't at the time that I gave this remembered to put in a better copy of this. So it's maybe not wholly visible. But if we return to what it is that is blindfolded and what it is that is not blindfolded within the juridical tradition, Stephen Bateman's English reformist text of emblems provides this extraordinary representation in a lengthy tradition that goes back to Brandt's Stultifera Navis and the image of the fool blindfolding Justitia. Here you have Justitia, and if you look closely, sword in the right hand, scales in the left hand, eyes gouged out. So she is blindfolded. But then in the center of the head, the frons, an eye, a third eye. It's moved from the chest to the head. That's not quite true because wither comes afterwards, but here we have this image of the centrality of vision to Justitia, and at the same time, the otherworldly character of that vision, of that image, of that interiority. So you have a judge to her right with a flayed corpse, another classical reference, a skin of a corrupt lawyer hanging in front of the juridical scribe, and then you have two parties appearing, ironically, before the judge. Appearing before a blind judge, except of course the judge is not precisely blind. This political theology of the Reformation is trying to show you a distinction between licit and illicit images. We have to be blind to certain things, things human, things immediate. At the same time, the judge needs to be able to see. The judge is the medium between the proximate and the physical, the written and the textual, and the imagistic. The judge herself here is an emblem of emblems, and that interiority of vision is the first indication of a transition to a different form of seeing. What I like most, and Agamben has written about this, the divinity is always represented through a crescendo of optical images. That's my translation, because the American translators got that sentence quite wrong. The closer you get to the divinity, the brighter the light, the less you see. That's the paradox. So the image, of course, is always, as the judge says here, like humanity itself, because we are images, as Augustine reminded us. We walk amongst images and as images. The image evaporates into absolute vision, which is, of course, the unseen. and unseeable. And the third eye represents that moment of movement from the visible to the more than visible. The eye of justice is the first indication, and you can see it equally well actually in Wither, but the first indication of all of these sources and disappearances into light. If you look at the Wither, 3 sources of light from the stars, from the sun, from the moon, all pouring down, all representations of the divinity refracted, because the divinity can never be directly seen. So Justitia herself, with her eye, is simply reminding us in the most graphic and surprising form that we are moving here from the visible to the lucent, to a light which is more than humans can see. And in that movement towards the lucent, we are moving from the realm of ratio scripta. We are moving from the world of the text and of writing into a domain of images, into a domain of light that cannot be rationally apprehended. It is a question of precisely desire, faith, and the trajectory towards the plus ultra that law cannot allow you to actually invest or inhabit. From Batman, I just want 3 more eyes, because there's a final moment of transition if my chairman, Professor Stramignoni, is willing to give me a few minutes, maybe, Umberto. So, the eye then shifts. And here the Impresas Morales of Juan Borgia. We find fairly common image of a scepter with an eye that we saw first in Anno. That the king must be constantly vigilant. The king must see everything. To rule properly, all must be visible. So then how can a blindfolded justice perform such a task? And the answer is that a blindfolded justice has to be subordinate to and domesticated by the higher source and power. So if you look here, the Impresas Morales are upon the monument that represents the work. Again, the closed book or the frontispiece, the face of the book, but not the book, not the text itself, the irony of all writing, and within that an eye on the scepter that looks out and that will see for Justitia. And then again, this from Pegenstecker, 1672. There are earlier editions, but this is the first instance of the emblem in this form, this most incredible representation of the relationship between the divine, the legal, and judgment. So, have a look at the unbroken eternal circle of Justinian, whose name comes, of course, as we're frequently told, from Just, with his crown, with his eyes, holding in his right hand an orb upon which an angel dances. The angel dances and places a halo over Domini Nostri Sacritissimi Justiniani. And in her other hand a quill, because Justinian will write. But inside the circle, but not of the circle, is the eye at the end of the scepter. So what we are being shown is the acquisition of an eternal vision through and by means of a borrowing, a transmission, a hierarchical descent from the eternal and unbroken circle of the law towards the figure of Justitia seated below, blind, sword in one hand, scale and scepters in the other, robed and with a species of theatrical curtain surrounding her, indicating transition. The books again, to the left of the image, vast tomes of law, because these tomes are our tombs, these tombs are our tomes. The image of the book. And then we see what is most important, which is just dari, the giving of the law, the handing on of the law, which comes ultimately from the angelological quill that is held by the angel to the side of Justinian, and then passes through and by means of the scepter and the eye to Justitia, who is blind and merely a conduit of that greater vision and greater power. But juridical theology is entirely contained therein. The books forming the point of transmission here of the law to the divine, and Justitia forming the visible motion of transmission of the vision of justice into its new place and realm. And the scribe with the quill and the books lying around to the side are common tropes in many, many emblems. And then finally, because there must always be an end, the allegory of the law. And there you see the light divine, the crescendo of the optical, the invisibility of the more than visible, state and law, and then a paltry, small, and I would suggest domesticated Justitia. She is subordinate and subservient, immobile and blindfolded, above the realm of the human, an ornament as much as she is an active player, a conduit as much as she is a principle of judgment. Because Justitia in this iconography, blindfold, is subject to another vision. Justitia is a mere medium of the image, and while she is the visible expression of law, she is not in any sense the inventor or the direct inscriber of such law. Simply the feminine image that portrays how it is that we give birth to law, and at the same time the feminine image through which the human disappears into the unknowable and the divine. A mythography as sad as it is prevalent, but nonetheless, all of that leads me to say that if you see an image of Justitia or anybody else blindfolded, the blindfold is not precluding the subject from seeing. The blindfold is indicating, on the one hand, that the human cannot go beyond here, that this is a point of transmission, and on the other hand, the blindfold is indicating that the eye is somewhere else, that the eye is in the other. Thank you. There is, of course, a third language that we can use, which is Schreber's Grundsprach. We can speak in the language of the automatic writing systems, and more than that, we can embody Schreber and we can bellow, because I want to suggest that bellowing, which is the one symptom of which Daniel Paul Schreber, the hapless jurist, was never cured of. He bellowed to the grave. And the etymology of bellowing, because I don't want to keep you waiting, because it's important to have the conclusion before we begin. Bellowing, brûlen, has its roots, mon prêtre, in bullae, which of course is papal, pontifical, and edictorial. He wanted to pontificate to the end, which in secular terms is to say, he wanted to legislate, to make law, to find his freedom till the very end. And that is why I love Judge Schreber. That is why I think Daniel Paul Schreber is the most magnificently honest jurisprud or jurisconsult. I think he embodied and enacted an unconscious that judges rarely dare to address or approach. So to the story itself, which I'm sure you know well, but Daniel Paul Schreber came to fame not so much through his memoirs as through Freud's study of his memoirs, published in 1910, his study of dementia praecox, and his rather uninteresting conclusion, although his wonderful depiction of Schreber as a victim of transference gone wrong and as a homosexual. His behavior explicable by virtue of the transference of his passion for an absent father to Professor Flechsig. And then when Professor Flechsig, that murderer of the University of Leipzig, that soul destroyer and impugner of Schreber's integrity, disappeared from the scene, then it was as a substitute for Flechsig that Schreber began his war on God. So the story itself has been written up by Freud. It has been written up by Lacan, and Lacan's theory is really quite similar to Freud's, but with some nuance. It is that Schreber is a case of foreclosure. The absent figure of the father, the lack of the nom du père, propelled Schreber into hallucination and into psychosis, so as to find a substitute for the foreclosed father. But that, again, I want to suggest, is just reading Schreber in terms of pre-existent categories of psychoanalysis. It is interpreting him in a lazy fashion, according to what we already know, as opposed to addressing and acknowledging the true juridical theology, jurisprudence, and legal brilliance of Judge Schreber. So my task is to read Schreber not as the utterance of madness, but as the utterance of law. What are the memoirs, if not the expression of a judge stating the law in a different form? So it is precisely as the utterance not of madness, but the mad utterance of law, that Schreber is interesting, important, and valuable to us, even today, for insights that we dare not address, laws whose name we dare not speak, inventions that we are afraid to acknowledge. So the history itself, just quickly, because I think this is really important, in 1884, the unknown Judge Schreber, a local magistrate, decides to stand for election to Parliament, to the Reichstag. He stands for election, and in English we would say he loses his deposit. Nobody votes for him, nobody is interested, nobody is heard. He is rejected, and he is rejected horribly. So he falls back into law. He falls back into law, and he suffers a nervous breakdown, the first incarceration. He suffers a nervous breakdown, he suffers from hypochondria, he suffers from insomnia, and he suffers from involuntary bellowing. Never really described, but vociferations is the way in which it is termed. He is incarcerated in the University of Leipzig psychiatric clinic, where he comes under the ministrations of Professor Flechsig. And Professor Flechsig cures him, it seems, of all, I will argue, but his juridical madness, or perhaps better, in more classical terms, his juridical enthusiasm. And he returns to work, and he is at a young age, in 1893, elected Supreme Court leader, chief judge of the Supreme Court, Senatspräsident, the highest office in the land, and Saxony at that time was still in juristic terms an independent principality, so this was head of the Supreme Court. I have no idea what the equivalent in Italy would be, but the legal Berlusconi or some such. That's a joke. I have no idea if that means anything. But the chief judge of the highest court. And shortly after that great honor, that high appointment, that elevation, he succumbs a second time, and this time in a much more virulent fashion, to madness. It is now that he really gets into his stride. And during this period, he believes he is becoming a woman. He is transferring into a woman physically. He is growing best. Every time that he bends down, he cannot, indeed, it becomes a matter of habit to imagine feminine buttocks. And this process of unmanning is by virtue of the intervention of God, who is in direct contact with Schreber. And God is intruding on Schreber with his rays and with other miraculous manifestations. Schreber is hallucinating, he's bellowing, he is not sleeping, he is seeing things, he is hearing things, and he is essentially dysfunctional. It is during this period of becoming a woman, during this period in which, when the process of unmanning is complete, God will copulate with Schreber, and they will produce a new human race. They will repopulate the world in its proper manner and according to the exact and precise order of the world. And while that process is going on, Schreber learns quite accidentally in 1895 that he has been sectioned, we would say in English, that he has been court-ordered a ward of the asylum. He has lost his legal capacity. He has, in juristic terms, been infantilized and incarcerated. He's surprised to learn this, because Schreber maintains magnificently till the very last day of his life, I have never been mad. I have never been in any way mentally disabled. So he brings a lawsuit, and that lawsuit is to prove his capacity. In 1900, much to his surprise, the district court reaffirms his incarceration and rejects his plea. And so he litigates again. And it's ironically before the Supreme Court, of which he had been appointed, the Chief Justice, that it is found as follows. After a lengthy trial in which the principal evidence were the memoirs of my nervous illness, the meticulously detailed record of his illness that Schreber kept, and his own litigation skills, his own ability to argue his own case and to make his own juristic arguments, together with his ability to negotiate a contract for his father's much more successful treatise on indoor gymnastics that allows for him to be released. The court holds that Schreber is without question mad. He is psychotic. He believes that his body is changing into that of a woman and that God is intervening in his body on a daily basis. All of that is legally cognizable as madness, but nothing the court says, nothing the court determines, nothing in his madness prevents him from acting as a judge and being legally competent. He is mad, but he is perfectly fit to be a lawyer because his madness does not connect to his legalism. His ability to be a jurist is not impacted by his insanity. So he can be released and he can sit as chair of a panel of judges if he so desires. The court holds him legally competent and fit to be a judge. It is Schreber who disallows any such intention. Schreber writes in his memoirs that when I pinned my flag to the banner of femininity, I gave up the profession I loved and the virile and manly pursuit of law and all other manly pursuits. I entered the realm of imagination. I entered the realm of images. And someone who has tied their flag to femininity, someone who wishes to indulge in their desires and imaginations, cannot practice law. So he disallows himself, but the court had never done such a thing. In consequence, it is he himself who disbars himself. So, 3 theses, because we are in a Catholic country and it's important to have a trinity of arguments. Some of you are ordained and therefore in respect of context and personage. The 3 arguments are, number 1, Schreber went mad of law and Schreber was mad with law, which is an English pun. Mad of law, mad with law. Everything begins with his attempt to escape from law. And I will trace that through his history. The memoirs themselves are full of law. They are all law. They are good law. They are in perfect Latin. All of the concepts correct and in order. So thesis number 1. This is the discourse of law and should be read as the discourse of law. Thesis number 2, insofar as Schreber was mad, his madness was a revision of juridical theology. Insofar as he was mad, his only question was the question of utrumque ius, his question of the relationship between the divine and the legal. Not political theology, but juridical theology. That question that all jurisprudes endlessly answer and which all jurisprudes present in differing forms. But how do we understand jus naturae? How do we understand the divinity in nature that expresses itself in the formulation and inscription of law? Are not all judges some version of that image of Ronald Dworkin that I presented on the first day of my trinity of lectures? Dworkin in nature, luxuriating in green and then white, emergent out of the rushes. How do we answer the question of what that means in any pragmatic or practical